applications in a matter of Global 100 Limited and Kyselakova and others.
May it please my Lord, yes. I represent the appellant in this matter, Global 100 Limited, and I lead Sean Pettit. My learned friend, Mr. Wanacott QC, represents Maria Laleva, the respondent,
yep.
and he leads Mr. Bano on this appeal.
Yes, you will no doubt understand that we have read the District Judge's judgment, Judge Luba's judgment, various skeleton arguments, and you will also not be surprised to learn we have discussed the case amongst ourselves. We are satisfied that it meets the criteria in Hutchison and Popdog. We are also satisfied that there are substantial arguments both on the appeal and the cross-appeal. So we will hear the appeal and the cross-appeal, and we give permission both to appeal and to cross-appeal, which I think, according to your timetable, saves us about 15 minutes.
My Lord, I was going to say thank you very much. That's really cut through the timetable. It's unusual for a timetable to run short. As you've will see from the timetable, we agreed between us, my learned friend and I, that he should make his submissions on title and Estoppel first, because we accept that if their argument on that is right, that's an end to the possession claim.
Yeah. Right.
Well, thank you.
Yes, Mr. Wanacott.
My lady, my lords, I will be dealing with the cross appeal, and my learned junior will be dealing with the appeal.
Right.
Because it's been a long time since I've been in the general possession list in the county court, and I think it's probably more useful to hear from him than from me.
Fine.
On the cross appeal, I'm going to start with Estoppel as to title, and then I'm going to move on to the title that is needed in order to bring a possession claim. On Estoppel as to title, our submission is really quite simple. The freehold owner gave Global permission to let me in, and I went in under that permission. So I am estopped from denying the freehold owner's title. If the owner says he's the owner, then as the old cases put it, my mouth is muzzled up from denying that. And that's because I can't take something from the owner with one hand and then say it was never the owner's to give with the other. That doesn't stop me saying to Global, you aren't the owner. You can't bring this action. And I'm allowed to say that because it's Global's own case that they are not the owner, that they only had the owner's permission to let me in. And the very short point is that Estoppel's work, by requiring a party to admit some part of their opponent's case, you can't have an Estoppel that requires you to deny some part of your opponent's case. If I admit, as I'm required to, that Global had the owner's permission to let me in, I'm still allowed to say only the owner can turn me out. And there are 3 cases that I'm going to take you to, just to make good that point. The first one is in tab 1 of the authority bundle. It's Doe on the demise of Johnson and Bator. It's a King's Bench decision reported in 3 Adolphus and Ellis 188. This is my Lord Justice Lewison will know this, but maybe the other members of the panel do not. This is an old ejectment case, and so the owner, Mrs. Johnson, grants a fictional lease to Mr. Doe, and Mr. Doe brings the action as tenant of the owner. And the facts are instructive. Mrs. Johnson, the owner, leaves the keys with a friend, Mary Batscombe, so that she can show it to people who might be interested in taking a lease of the house. And Mrs. Johnson's stepdaughter gets the keys from Mary Batscombe by fraud. She says to Mary Batscombe, I want to go and collect vegetables from the garden. Mary Batscombe hands over the keys to the garden, which also include the keys to the house, and she then goes and squats in the house. So it's the same sort of arrangement as we have with the guardians. The owner grants a permission to the guardians, to the guardian company. Guardian company lets in the occupiers. Now, the key point about Johnson and Bater is that the claim for possession wasn't brought by the person who granted the license to go into the garden, Mary Batscombe. It was bought by the owner. And so the issue in Johnson and Bater is whether Miss Bater is stopped from denying that Mrs. Johnson is the owner. And the answer is that, of course, she is. And the judgment of the Chief Justice, Lord Denman, is the rule must be made absolute. In this transaction, the defendant waived any title which she might previously have been able to assert. She held possession through a license, whether for a longer or shorter time is immaterial. She cannot claim against the party by whom she was let in. That party, as between them, has the title. So he can't deny that the owner, who granted the license to Mary Batscombe, who granted the license...
Was she let in by Miss Batscombe?
She was, yes.
So when Lord Denman says she cannot claim against the party by whom she was let in, is that not Miss Batscombe?
No, that is the claimant in the action, Mrs. Johnson.
Well, it is on the particular facts, but the principle that is stated is rather wider.
Well, perhaps if you go to the judgment over the page of Mr. Justice Coleridge, you see that in fact it is the narrow principle. He says, 3 lines down, the licensee, by asking permission, admits that there is title in the landlord.
Yeah.
So, my Lord, you're quite right. You can perhaps interpret Chief Justice Denman's judgment as a wider principle, but Mr. Justice Coleridge is quite clear it's an admission of the landlord's title. And that makes perfect sense, because everybody knows that Mary Batscombe hasn't got any title.
Well, nor had Mrs. Johnson.
Well, Mrs. Johnson did have a title, because she had previously been in possession, and prior possession gives a title. And what was actually happening in this case was that the stepdaughter was trying to reverse the burden of proof by getting possession herself. It was a family dispute, where there was a dispute as to whether Mrs. Johnson was entitled to the property.
Well, just hang on a minute. If you look in the middle of the recitation of the facts, the defence, this is halfway, just above the 190 in square brackets, the defence was that the house had been Johnson's own, Mr. Poyns had no right to grant a lease of it, and that Johnson's widow, she's the plaintiff, showed no title, there being no will produced.
Yes.
So Mr. Justice Littledale leaves that case to the jury, and they found for the defendant. So Mrs. Johnson didn't have title.
Well, Mrs. Johnson had a prior title by possession because she had previously been in possession, as is recited at the top. And the question was whether, by accepting the license, Miss Bater was deemed to have omitted that title, and so if she wanted to assert a title of her own, she had to go out of possession to do it.
Yeah.
The second case that makes it quite plain that what you do is you admit the title that is asserted against you is Terence and Terence, which my Lord Justice Lewison sent reference to, and which I think is tab 30 of the authority document.
Tab 30.
30.
Yeah. Thank you.
Case in the Privy Council where land is vested in the chief priest of a temple, in effect as a corporation sole. And the person claiming to be the chief priest grants a license to a monk to occupy it in return for a share of the produce. And when the monk stops paying, the chief priest brings possession proceedings, and the monk's defence is you're not really the chief priest. And not surprisingly, the Privy Council held that he was, having taken the licence from the chief priest as if he were the owner of the land, the monk was stopped from denying that he was the owner of the land.
Well, but the priest, the chief priest, he was a chief priest, right?
Yeah. The crucial point is the land is vested in the chief priest, whoever the chief priest might be.
Well, just if we go to the facts in 1087, the chief priest executes a deed conferring certain rights and duty on the appellant, who's the priest, a priest.
Yeah.
Not necessarily title, not necessarily a lease. He's got certain rights and duties.
Yeah.
The appellant, with the certain rights and duty, permits the respondent to live on the temple property. There's no title here.
Yes, there is, because what happens in 1944 is the chief priest dies, and the appellant takes on the position of chief priest. And afterwards the tithe continues to be paid, and that is what establishes the estoppel for him being the chief priest.
Right. Yeah.
And the relevant principle stated in the judgment of the board delivered by Lord Devlin is at 1093. And it's the bottom of the page, letter G. For the purpose of the argument on estoppel, it's unnecessary and indeed irrelevant to consider what the appellant's title truly was. The question is, what was the title which the respondent was apparently recognising? And this depends on the title which the appellant was apparently claiming. The appellant in this case is claiming to be a licensee. That is the only title he's claiming, that is the only title I am required to recognise. And the issue is whether I can say, as a matter of law, that's demurrable.
That assumes that a licensee cannot have possession.
Yes. Estoppel is muzzling me up from running that argument. The question is whether I'm allowed to run the argument. I'm allowed to run it, I say, because the title I'm recognising is a licence. And because I'm recognising that it is a licence, because that is the claimant's own case, I'm allowed to say that's not good enough. Now, you'll have to decide whether that argument's right or wrong, but this is just the preliminary stage of whether I'm allowed to argue it. The final case I want to refer to on Estoppel is at tab 11, and that's Bruton.
Can I just so you would say that what Lord Devlin says at 1092G doesn't prevent you from arguing that a licence that all you have recognised is that you have taken a licence from G100.
Well, I've done more than that. I've recognised that there's an owner who has title.
Where have you done that?
Well, the licence refers to the license, sub-license to me, refers to the fact that there is an owner,
right,
from whom the global group
yeah,
have obtained permission to let me in.
right.
So what I have recognised is that there is an owner, and what I have recognised is that the owner has given permission to the global group to let me in. And I have recognised that I am under those arrangements, I cannot say that Global didn't have permission to let me in. But I am allowed to say, you're not the legal owner, because that is your own case. And I am allowed to say that as a matter of law, the claim has to be brought by a legal owner.
Yeah.
The last case on Estoppel is Bruton and London and Quadrant Housing Trust, which is tab 11. Now this is a case where you had freehold owner grants a licensee enters into an arrangement with the occupier. But the crucial fact about Bruton and Quadrant is that the parties are the other way round. In that case, because it was an action for disrepair brought by Mr. Bruton, and in order to bring the action for disrepair, he had to assert that he was a tenant. And so in that case, Mr. Bruton is saying, and succeeded in saying, that as a matter of construction of the agreement between him and London and Quadrant, it was a contract for a tenancy. And because it made a contract for a tenancy, London and Quadrant were not allowed to turn round and say we only ever had a license. So it's completely the other way round from this case, where Global are saying we only had a license, that's our case, and I'm saying, well, that's just not good enough on your own case. Could you leave Bruton open, please, because we will come back to that. We'll come back to it after I've said a few words about the guardian model, the way guardianship works. There is a vanilla model. The owner pays the guardian company to guard the property, and the guardian company employs the guardians to do so. And under that vanilla model, there can be no doubt that the guardians are service occupiers and not tenants. But this scheme is really quite different.
are you right about that factually? Normally in these guardian schemes, there's no employment.
I'm sorry.
The guardians are allowed to live in the property, usually paying some kind of fee to the guardian company in order for them to provide the guardian services.
My Lord, you're quite right. There isn't technically a contract of employment. There is a requirement to occupy for the better performance of services.
Yes.
And the guardians make some contribution for their occupation.
Yeah.
And it's a reduced contribution because they're performing services.
Yeah.
Although not.
Those are the schemes that
yes.
I've encountered.
Yeah. That's sort of the Camelot model and so forth.
Yeah, and the Ludgate and Ricketts model.
Indeed. This scheme is really quite different. The owner pays the guardian company nothing to guard the property. It's all done for free. The occupants then pay the guardian company for the privilege of occupying their rooms, and the guardian company pays a share of that on to the owner. Now, as you'll hear from my learned friend in due course, we say there's an arguable case that's short-term letting dressed up as guardianship. And the question on the appeal is whether we should be stopped from arguing that at trial. But whatever the scheme, there is always a commercial imperative for the guardian company to ensure that it only acquires limited powers over the property. It's essential under every scheme that the guardian company does not obtain exclusive or general control, because as my Lord Justice Lewison will appreciate, having done the case, the consequence then would be that the guardian company would go into rateable occupation. So in every case it has to be limited control for limited purposes to ensure that doesn't happen. That's why you will not find a word about control or possession in the contract between the owner and the guardian company. It's all about management and occupation. Now in this case, in fact, 8 days before the possession claim was brought, an additional agreement was executed between the owner and the guardian company, purporting to give it a right to bring these proceedings. And we probably ought to look at that. That's at 265 of the appeal bundle. Right up there.
Yes. There was something I didn't quite understand about this document. What's clause 11 of the terms of the agreement?
I'm not sure. It may be that the agreement has been mangled. Because it's not actually numbered.
No, and the first recital talks about standard terms. Now, I'm not sure whether that's the document that we've got, which is a sort of offer letter, whether there's something missing. I simply don't know.
I think on any view it would not be claimed that the temporary license agreement or the agreement with the owner is a beautiful document that does the draftsman credit.
No.
But this is their attempt to put it right. You'll notice it's made with Global Guardians Management Limited, who are not the claimant in this action. And the operative part purports to confer on that company a right of possession of the property for the sole purpose of enabling eviction of the licensees. Now that is peculiar. It's not. It doesn't purport to be complete possession, because that would put them into rateable occupation of our side. It purports to be a severed right to possess for a particular purpose. And as my Lord Justice Lewison will know, because he argued Pye and Graham, possession is single and exclusive. If A is in possession of land and no one else save a joint possessor can be. It's not something that could be chopped up into bits. If I'm in possession, someone else isn't. If someone else is in possession, I'm not. Same with a right to possession. You can't have a right to possession for particular purposes vested in someone, but a right to possession for other purposes vested in somebody else.
No, you can't, but you can have a right to possession which limits your use of the property.
Oh, yes, you can. But if you have a right to possession which limits your use of the property, then you go into rateable occupation, because you are the possessor. There is no one else in possession, because possession is single and exclusive.
Well, that may be so, but we're not concerned with rateable occupation in this case.
No, we're not. We're concerned with construing this agreement. And the question is, does this agreement give a complete right to possession, but limit the use to which it can be put? In which case, it would be conferring a right to possession. Or does it purport to grant possession only for a limited purpose, whilst reserving possession for other purposes to the grantor, in which case it is ineffective to confer possession on the grantee?
Wouldn't you construe it so that it actually has effect?
Well,
To save the agreement as opposed to
if you
destroying
construe
the agreement?
well, yes and no.
Irrespective of the rate consequence for rates.
Yes and no. Yeah, you could construe it to have effect, but the effect that was trying to be achieved was to confer possession only for a limited purpose. That is a purpose that's something that simply can't be done as a matter of law. And so the question is, do you then construe it to say, well, actually it means possession for all purposes, or is it ineffective as an instrument? And because it says sole purpose, you simply cannot construe it as conferring possession for all purposes. Any more than when someone wants to create a license and inadvertently creates a tenancy, you would go through with a red pen crossing out everything that makes it a tenancy to turn it back into a license again.
So what does it do, if anything?
It's a contractual right, as between NHS and Global Guardians for that purpose, and it might impliedly give Global Guardians power to bring a claim in the name of the owner. That is how you give effect to it.
So a sort of agency agreement.
But it really doesn't matter because it's made with the wrong company.
Yeah.
That brings me to the grounds of the cross appeal. And the first ground is, I put it this way, the Spartan ground. You need a legal title to bring a possession claim, full stop. The second ground is, even if something less will do, it has to be a right of exclusive control, and this claimant does not have a right of exclusive control. My lady, my lords, I ask you to keep Bruton at tab 11 open. Could you go forward, please, to 408? At letter D contains the argument of my Lord Justice Lewison. You're going to think in this case that I've just gone through trawling, looking for arguments and dictum from Lord Justice Lewison. I honestly haven't. But the argument here, we say, accurately summarises the effect of the House of Lords cases, which we refer to in our skeleton. And the argument is this. Title in English law is founded on possession. It is a fundamental principle that a person who has possession is entitled to exclude all others from the land except a person who can show a better title. And we respectfully adopt that as being correct, and we respectfully agree that that is a fundamental principle of English land law. And so, on the Spartan argument, Global says I'm a trespasser. Global says that it is a licensee. A license is not a better title than my legal estate. As a trespasser, I am deemed to have a fee simple estate from the moment I start trespassing, which is good against the world, except someone who can show a better title. Why isn't a contractual license a better title?
Well, hang on a minute. As a trespasser, I'm deemed to have a fee simple title. Well, yes, if you've got possession.
I have possession because...
Well, that's what you say, but that's one of the questions, isn't it?
Well, first of all, it isn't a question on the claimant's case, because it's the claimant's case that I am in possession, it wants to recover possession from me. And secondly, as your lordship will know, having argued the case, in High and Graham, a licensee who held over was deemed to be a possessor. And
well, no, he was a possessor on the facts.
Yeah. Well, the claim against me is that I'm in possession.
Yeah. Yeah, now I see that.
And indeed, the claimant is muzzled up from denying that I'm in possession. Now, it could have brought the claim differently, of course. Could have said, you're not in possession. I've got a contractual relationship with you. I'm going to sue on the contract and ask for an injunction. If it had done that, injunction might or might not have been granted, but there would have been no conceptual objection to that.
Yeah.
So why isn't the title that it claims a better title? Because in the classic words of Chief Justice Vaughan in Thomas and Sorrell, which for your note is referred to in Ashburn, Anstelt and Arnold, tab 8, pages 13 and 19. A dispensation or license properly passeth no interest, nor alters or transfers property in anything, but only makes an action lawful, which without would have been unlawful. And the classic exposition of this is in King and David Allen bill posting at tab 6. Which is a decision of the House of Lords which was not cited in Manchester Airport and Dublin. And this is one of those cases that we're almost certainly taught at law school. It's Mr. King granted David Allen an exclusive license to put advertisements on the flank wall of a cinema. He then granted a lease to a company of the cinema, and the cinema company said, we're not bound by the license. And so David Allen bill posting sued Mr. King for disposing of for granting a lease which put it out of his power to allow David Allen to put their bill posters up. And the argument for Mr. King was that the tenant was bound by the license, that the license could be enforced against the tenant. If you go, please, to page 57 in the report, you can see the argument. About halfway down, said the respondents ought to have sued the picture company, and if the picture company can be sued, the appellant is free, for he committed no breach of his obligation. In other words, you can enforce your license against the tenant, therefore you can't sue me. And the House of Lords unanimously decided that that was wrong, that the license couldn't be enforced against the tenant. They didn't even call on counsel it wasn't counsel for the tenant, it was counsel for David Allen bill posting. And if you go, please, to page 60 in the speech of Lord Buckmaster, Lord Chancellor, he says at the top of the page, those considerations do not, in my opinion, necessarily conflict with the view that this is nothing but a license for a fixed term of years, but a license which creates no estate or interest in the land upon which the palace is going to be built, nor an easement upon which be subject thereafter. And then over the page at 61, the paragraph beginning between the hole punches, the matter then is left in this way. There's a contract between the appellants and the response which creates nothing but a personal obligation. It is a license for good and valuable consideration and to endure for a time. But I fail to see, when I've done my best to follow the many authorities which the learned Solicitor General has thought it right to place for our consideration, that there's any authority for saying that any such document creates rights other than those I've described. And Lord Lorreburn over the page says in the long passage between the two hole punches towards the bottom hole punch, but we must look at the document itself, and it seems to me it does not create any interest in land at all. It amounts merely to a promise on the part of Mr. King to allow the other parties of the contract to use the wall for advertising purposes. There's an implied undertaking he will not disable himself from carrying out his contract. And Lord Atkinson over the page agrees. And that's why a licensee cannot bring a claim in nuisance. Uncontroversial that the House of Lords decided that in Hunter and Canary Wharf. And that's also why a licensee cannot sue in trespass.
So what does a lodger do who finds a stranger in his room?
He can physically evict him, but he can't bring an action in trespass. The action in trespass has to be brought by the landlord. And authority for that is Ludgate House and Ricketts, which is tab 23 of the authority bundle. This is the decision of my Lord Justice Lewison in the case about whether, by granting a guardian company permission to allow occupiers to occupy, the owner went out of rateable occupation. And this court held not, but the passage that I'm going to take you to...
I'm not sure we did hold that, did we? We held that the guardians were not in rateable occupation.
Yes, you held the guardians weren't in rateable occupation.
I think
The
that's all. That was the only issue in the case, wasn't
No, the issue in the case was whether...
it? Was one hereditament or more than one? I think.
The issue in the case was whether the hereditament should be deleted from the rating list,
Yeah.
which showed Ludgate House as the rateable occupier by reason of the occupation of the guardians. When you decide that the guardians are not in rateable occupation...
Yeah, therefore the hereditament remained the same. I don't think we decided who was in rateable occupation of it.
Well, because the hereditament remained the same, the application to delete Ludgate House as the rateable occupier from the rating list failed, with the result that Ludgate House continued to be in rateable occupation.
I'm not sure we actually decided that. That may be the consequence, but
It was actually an application to derate Ludgate House as the rateable occupier.
Well, it was an application to, I remember it, to delete the hereditament from the rating list. Yeah. Yes.
My Lord may be right. It may be, what I'm stating is the inevitable consequence of the judgment rather than what was technically the issue.
But I certainly don't think we decided that whether, as between Ludgate House and the Guardian Company, one or the other was in rating.
No, you certainly didn't. The passage I want to take you to is 171 at paragraph 73. So 1771. Where my Lord Justice Lewison answers the question you've just asked me about what the lodger can do. Because at paragraph 72 you refer to Allen and Liverpool overseers, and you point out that Miss Justice Blackburn had decided that a lodger could not bring ejectment or trespass quare clause and frigate, the maintenance of the action depending on possession, and he is not rateable. And then at 73, 4 lines up from the bottom, my Lord says, if, as Mr. Justice Blackburn held, the test is whether a guardian would be entitled to maintain an action of trespass, it seems to me clear that the terms of the licence did not give him exclusive possession, which is the necessary foundation for an action in trespass.
Yeah.
So, in both nuisance and trespass, the foundation of the action is possession, exclusive possession. Same thing. And we ask, if a lodger or a licensee in occupation can't bring an action for nuisance, and he can't bring an action for trespass, he can't protect his occupation in that way, how, in logic, can he bring an action against a third party in trespass, sorry, how can he bring an action to exclude intruders and be put into occupation?
Do you mean put into possession?
I avoided using the word possession.
Right. Put into occupation.
Yeah, because that carries with it issues.
Yeah.
If we treat a licensee as an occupier, and as an occupier he can't sue a nuisance, so can't deal with smells or environmental torts. He can't sue in trespass. If someone actually comes onto the land, he can't sue himself. He has to sue in the name of the licensor, because his occupation isn't good enough for that. How can he bring an action against intruders when he's out of occupation to be put into occupation? Just can't be right, particularly given that an action for recovery of land is a species of trespass. Trespass and ejectment and trespass quare clause and frigate, they both have the same root. That brings us to the troublesome case of Manchester Airport and Dutton at tab 10 of the authority bundle. This was a case about building of the second runway at Manchester Airport. Manchester Airport needed a clear flight path at the end of the runway. There were some woods at the end of the runway that belonged to the National Trust, and the National Trust granted Manchester Airport a licence to enter and cut the woods to create the clear flight path. But shortly before that was done, Dutton and others set up an environmental camp in the wood to try and prevent it happening. And the question was, could Manchester Airport, as a licensee, bring an action for possession so as to recover possession of the woods? The case was argued for the protesters by a litigant in person, Christopher Mayle. It was argued for Manchester Airport by leading counsel, who quite properly, in his skeleton argument, referred to Ashburn and Staunton Arnold, which is the case that decides the modern case that decides that a contractual licence isn't binding on third parties. But it wasn't cited in argument. It isn't referred to in any of the judgments.
Oh, I see, yes.
And Lord Justice Chadwick dissents. He says, no, it's a fundamental principle that you have to show a better title. A licence isn't a title. But Lord Justice Laws and Lord Justice Kennedy allow the possession claim to be made and grant the possession. And the judgment of Lord Justice Laws starts at 147. At 147H, he says, but if the airport company were it in actual occupation and control of the site, could obtain an order of possession against the trespassers, why may not it obtain such an order before it enters occupation, so as to evict the trespassers and enjoy the licence granted to it? My lords, if by actual occupation and control of the site, he means if the airport company had been in possession before the trespassers, then that would have given it a title to recover possession.
I don't think he does mean that, as the rest of that paragraph makes clear.
I'm not sure that's right, Milord. I think when he says, but if the airport company were it in actual occupation control of the site could obtain an order of possession against trespassers. In other words, taking that to be right, why may it not obtain such an order before it enters occupation so as to evict the trespassers and enjoy the license granted to it?
Well, is that right? I mean, when he discusses what the airport company could have done had it got there first, to use a neutral expression, he says at D, if the company had been in actual occupation, trespassers had entered, the company could have obtained an order of possession if it was in effective control of the land. Airport company's claim for possession would not, were it in occupation, fall to be defeated by the circumstances that it enjoys no title or estate, nor any right of exclusive possession against its licensor, which the National Trust had no power to grant. So he's contemplating there that it doesn't have exclusive possession, isn't he?
My Lord,
beforehand.
He may be, if that's what he means.
And then he says, well, if that's the position, if that's the before position, if that's the after position,
Yes, quite.
why should the before position be any different? That seems to me to be his reasoning.
Our answer to that is that it's very important to maintain the distinction between occupation and possession. They're not synonyms.
No, I understand that.
Yeah, and
that's why you say law, justice, laws is wrong.
Yes.
I understand that too. But just simply looking at what he's saying.
he appears to be saying occupation. I agree.
Yeah.
If that's what he's saying, then it is inconsistent with what my lord said in the rating case. And it's inconsistent with Mr. Justice Blackburn's decision about the lodger, because the whole point is, if it's just occupation, if it's not possession, you cannot bring an action in trespass.
Yeah.
And then he continues, as I understand it, the principal objection to the grant of such relief is it will amount to an ejectment. An ejectment is a remedy available only to a party with a title or estate in land, which as a mere licensee the airport company plainly lacks. And then over the page at B, he says, in this I hear the rattle of medieval chains. And then at 149 between C and D, he says, in my judgment, the old learning demonstrates only that the remedy of ejectment was not concerned with the potential rights of a licensee. And then E and F, he says, as one might expect, this is wholly in line with the old law, but I think there's a logical mistake in the notion that because ejectment was only available to estate owners, possession cannot be made available to licensees who do not enjoy de facto possession. The mistake inheres in this: if the action for ejectment was by definition only concerned with rights of estate owners, it's necessarily silent on the question what relief might be available to a licensee. Limited and specific nature of ejectment means only that it was not available to a licensee. It doesn't imply the further proposition that no remedy by way of possession can now be granted to a licensee not in occupation. Well, if the cause of action isn't ejectment, what is it? He seems to acknowledge that the cause of action can't be ejectment. It must be some new tort. Now, admittedly, the county court has unlimited jurisdiction in actions in contract and tort. creating a new tort on the hoof is the kind of judicial legislation that was deprecated by the Supreme Court in Secretary of State for the Environment and Mire. And it's wholly inconsistent with King and David Allen bill posting that says that a licence is only a personal obligation that can't be enforced against third parties.
And is that the foundation of the per incuriam argument?
It is. In the same way as in Ashburn-Anstalt and Arnold, this court found that the proposition in Errington and Errington and Woods that a licence was binding on a third party was a decision made per incuriam because it hadn't made reference to King and David Allen bill posting. The dictum of Law, Justice, Laws is per incuriam because it ignores King and David Allen bill posting, Ashburn-Anstalt and Arnold, and it's also inconsistent with what my Lord Justice Lewison says in the rating case.
Well, that wouldn't make it per incuriam.
No, it would mean that there were two inconsistent decisions of the Court of Appeal and you could choose between them. Just for your notes, I'm not going to take you to it because of the time. The reference to judges not being legislators comes from Secretary of State and Mire, which is tab 15. It's in the speech of Lord Neuberger at paragraph 59.
Yeah.
And then the judgment of Lord Justice Kennedy starts at 150. And going over to 151B, the essence of his judgment is the plaintiff does have a right to possession of the land granted to it by the licence. It is entitled to enter and occupy the land in question. The mistake there, we respectfully suggest, is treating occupation and possession as synonyms. A person may have a right to enter and occupy without acquiring possession. A hotel guest has a right to enter and occupy his room. He has a key to keep people out, but he's not in possession. A hotel guest cannot maintain trespass or bring an action for recovery of land any more than a lodger can. And if you go back down to letter E, there's a quote from Danford and McNulty where, again, Lord Justice Kennedy adds the emphasis, and he accepts, indeed he emphasises, the requirement to show a superior legal title. And he treats the licence as if it were a superior legal title. Well, immediately after Manchester Airport and Dutton, there were a series of cases where this court rode back from the wide statement of principle which are all set out in our scope. I'm not going to take you to them because of the time. But in essence, the court, in all those cases, says, well, there has to be something like possession or exclusive control. It's not enough that it's simply a right to enter for limited purposes. Now, there's some principle here that the court is trying to grasp at, trying to work out. In each case, the core concept is, well, if there's a right to control, there's a complete right to control, then you ought to be able to bring a possession action. As indeed you should. And this is the proposition of law that we say will incorporate what the court was trying to do in Dutton, but return matters to orthodoxy. I have in my head Lord Justice Millett saying that the court's repudiated the heretical notion that a licence is an interest in land binding on third parties. And the way to do that is to say that where a person is given complete control of land under a contract, and that contract does not create a leasehold term, then that party is a tenant at will of the land unless and until he's told to leave by the other party. Now, tenant at will has possession. And that is a perfectly familiar situation when a purchaser of land is let into occupation before completion. He's a tenant at will, he has possession, he can evict strangers, he can rely on his tenancy at will to protect his possession. Now, if the tenancy at will is terminated, even if it's terminated in breach of contract, then possession reverts to the grantor. Now, I see my Lord Justice Lewison looking puzzled. That's because we tend to forget these days that there are three types of tenure. There is freehold tenure in fee simple, socage tenure. There is leasehold tenure for a term. And the one that's forgotten is tenancy at will. That's a tenure too. And we get dazzled by contract, thinking it's all contract. And it isn't. If you have a contract that allows someone complete control, then in land law they become a tenant at will until that contract is ended.
Well, I'm not sure that Manchester Ship Canal and Vauxhall Motors would fit with that analysis. There you had a perpetual licence granted to Vauxhall to construct drainage facilities at its factory on Merseyside. It wasn't a lease because it was perpetual,
yes,
as you yourself know
yes,
perfectly well from your erudite argument in Mexfield. So it wasn't a lease. But the question was it, could it be relieved against forfeiture?
yes.
If it was no more than a tenancy at will, it seems odd that the Supreme Court said, well, yes, you can relieve against forfeiture.
Not at all odd, my lord, because it is a tenancy at will at common law, and relief from forfeiture is something that takes place in equity. And it is perfectly ordinary for someone to have a different status in common law from the status they have in equity. And because of Walsh and Lonsdale and the Judicature Acts, we have forgotten this. But it's quite possible to have that dual status. In equity, I'm entitled to relief from forfeiture of this contract. At common law, in the meantime, I'm a tenant at will. When I'm suing at common law for trespass or nuisance or ejectment, I'm entitled to rely on my status as a tenant at will. And all the old cases about uncertain terms are cases where there's lack of formality at common law, and so the court says, well, you're a tenant at will. Doe demise on the demise of Warner and Brown, for instance, in 1801. And the court says, if you're something else in equity, go off to equity and enforce your rights in equity. But in this court, you're just a tenant at will, because your agreement does not comply with the formalities that are required at common law to create a lease or whatever it is. That is the route.
But wait a minute, Walsh and Lonsdale, which you mentioned,
Yes.
there's an agreement for lease,
Yes.
and the question, if I remember rightly, was about whether you could levy a distress, which is a purely common law remedy.
Exactly.
And did not Sir George Jessel say that you could, because equity regarded the lease as if it had been granted?
Exactly.
But is it so is that a mix and match of equity and common law, which you say is impermissible?
No, my lord, you have to imagine you're deciding this before 1873 when it's administered by two separate courts. Walsh and Lonsdale, imagine Walsh and Lonsdale happened before 1873. Common law, action to replead the goods because the distress was unlawful. The distress was unlawful at common law because there was no express right in because there's no common law right to levy distress for rent that's payable in advance. So common law court would have said that's that. In equity, because there was an agreement for a lease which contained a power to levy distress for rent that was payable in advance, the Court of Equity would have granted a common injunction to stop the litigant in the common law court, to shut up his mouth from saying in the common law proceedings that there was no right of distress. That's how it worked before 1873. Afterwards, it all works in the same court at the same time. The intermediate steps are gone, and that is what has caused us to forget that someone's status at common law may be different from their status in equity. And when you're looking at common law causes of action, the status of a tenant at will is sufficient to bring those actions.
Right.
Well, that's the principle we offer. I see I'm coming up to my last 2 minutes. That's the principle that the court is searching for in these cases that gets things back to where it should be. But even if you don't accept that, you think that I'm wrong, there's still a requirement for complete control. And this agreement didn't come close to conferring the necessary control on the appellant. First of all, because of its terms, but secondly, because it's with the wrong party. My lady, my lords, I've run 2 minutes short. Do you have any questions for me?
No, thank you very much.
That brings us to my learned friend there.
You're going to reply both to the cross appeal and open your appeal.
That's right.
That's the next chunk.
Absolutely.
Right.
Yes, my lord. So, my lord, my lady, my learned friend took you to the agreement at page 265, and I just wanted to clear this up for you so you can see where it appears in the original agreement between NHS and Global Guardians. That's the very last page of the hearing bundle, my lord, my lady.
Yeah, 265.
Yep, you'll see there, little Roman 3, but in accordance with clause 11.1 of the standards terms, and then there's a passage in italics.
Yes.
If you turn back to page 248, which is part of the agreement between NHS Property Limited and Global Guardians, you'll see at the top of that page that's that part of the agreement set out. Upon termination of the agreement between GGM and the owner of the Guardians of Gate property.
Well, compare that with upon termination, GGM will yield up possession of the property. That's what I couldn't understand. I couldn't find this phrase. First of all, I couldn't find a clause that was numbered 11.1.
No.
And secondly, I couldn't find this phrase, GGM will yield up possession of the property. It is perfectly
Lord, yes.
true that page 248 says the Guardians will vacate, but where would I find the words in italics? It rather looked as though there was a separate document somewhere
Yes.
called standard terms, which we don't have.
My lord, yes. I mean, that's the closest we've got in the documentation that we have.
Yeah.
So, my lord, if I could start with a reference to ejectment claims. So ejectment claims were devised by the medieval courts to fill a gap. A lessee could not bring a claim to oust a squatter in possession before ejectment claims were devised. They weren't the creation of statute, and at that time only a freeholder could bring a claim for possession, and that was the novel disseisin claim. An ejectment claim turned out to be more convenient than actions available to freeholders, and as my learned friend has referred to in the first case in the bundle, tab 1, Dodie Johnson, a fiction arose whereby the freeholder granted a fictitious lease, they granted a lease, but it wasn't one that was intended to inure beyond the claim for possession. And so freeholders started using ejectment claims, and that's why we have reference in a lot of the claims to Dodie and Roe, who were fictitious characters, Dodie being the person who granted a lease, and Roe being the person to whom who was in occupation. The fact that the ejectment claim was a creation of the courts, in my submission, was recognised by Lord Justice Laws in Manchester Airport and Dutton in the passage of his judgment at pages 148A to 150D. That's tab 10. In the paginated, using the pagination numbers, it's pages 170 to 172.
Sorry, which pagination?
I apologise. It's not. It's 148. I apologise.
Lord Justice Chadwick you're talking about?
Yeah. No, it's not Lord Justice. So it's Laws. Sorry.
178.
Page 148. That's page 178 on the paginated pages.
Yeah.
To page 180. Turning over the page to page 180, page 150 in the judgment at letter D. Lord Justice Laws recognised, in my submission correctly, that the issues arising on a claim for ejectment was an issue relating to remedies. He said as follows: in this whole debate, at letter D, my lords, my lady, in this whole debate, as regards the law of remedies, In the end, I see no significance as a matter of principle in any distinction drawn between a plaintiff whose right to occupy the land in question arises from title and one whose right arises only from contract. In every case, the question must be what is the reach of the right and whether it is shown that the defendant's acts violate its enjoyment. If they do, and as here an order of possession is the only practical remedy, the remedy should be granted. So what, in effect, is the argument in relation to ejectment claims is that something that was a creation of the courts in the first place is now create substantive principles which the court cannot, in relation to remedies, further develop. So an analogy with Shakespeare is that we should all do bowdlerised versions of Shakespeare and we shouldn't be able to interpret him for ourselves in our current time. In Mayer, Baroness Hale effectively recognised the same issue. So Mayer is at tab 15, my lords, my lady. The speech of Baroness Hale starts at page 2787 in the judgment and 259 in the paginations in the bundle. The relevant passage, my lords, my lady, starts at paragraph 26 on page 260 in the bundle, page 2788 in the judgment. And concludes at paragraph 35 over the page on page 263, page 2791 in the bundle. Baroness Hale said as follows at paragraph 35. It seems clear that the modern possession action is there to protect the right to physical occupation of the land against those who are wrongfully interfering with it. The right protected to the physical occupation of the land and the remedy available, the removal of those who are wrongfully there, should match one another. The action for possession of land has evolved out of ejectment, which itself evolved out of the law for trespass. There is nothing in CPR Part 55 which is inconsistent with this view, far from it. The distinction is drawn between a possession claim, which is a claim for recovery of possession of land, Rule 55(1)(a), and a possession claim against trespassers, which is a claim for the recovery of land, which the claimant alleges is occupied only by a person or persons who entered or remained on the land without the consent of a person entitled to possession of that land, Rule 55(1)(b). The object is to distinguish between the procedures to be used where a tenant remains in occupation after the end of his tenancy and the procedures to be used where there are squatters or others who have never been given permission to enter or remain on the land. That, to my mind, is the reason for inserting only, not to exclude the possibility that the person taking action to enforce his right to occupy is also in occupation of it. There is then provision for taking action against persons unknown, but the remedy in each case is the same, an order for physical removal from the land.
Right. Who, if anybody, agrees with that in the Supreme Court?
So, Lord Roger, at paragraph 6, at page 256, my lord, which is 2784 in the bundle, refers, in my submission, with approval to Manchester Airport plc and Dutton. And Lord Walker, my lord, at page 259 in the bundle, 2787 in the report, agrees with all the members of the court that the appeal should be allowed to the extent of setting aside the wider possession order. It's perhaps helpful if for your colleagues, my lord, if I explain that this was a claim in which the Forestry Commission, through the Secretary of State, was claiming a possession order against travellers and an injunction preventing them from entering onto land after they had been removed from it. The possession order that was sought, the Forestry Commission owned land in separate parcels.
They wanted a very wide range.
They wanted a very wide possession order.
Yeah.
The appeal was allowed to the extent that the possession order was only made in relation to the Forestry Commission land that was occupied and that was in the same wood or forest as the land that was occupied. It is right, my lord, that Lord Newburger, at page 2793 in the report 265 in the bundle, was more circumspect, and he refers in his decision in the Mayor of London case, which we'll come to in a moment, at paragraph 60 to 69. As providing some support for the arguments in effect put by my learned friend today. But in Mayor of London, in my submission, it's clear that Lord Newburger does not suggest that his position in Mayor was correct. I'll come to Mayor of London in a moment. That's behind tab 16, my lords, my lady. If my learned friend is right, in a situation equivalent to Bruton and London and Quadrant, and I'll explain that situation for my Lord Snowden and my Lady Macur, in that situation, a London local authority had granted a housing association, London and Quadrant, a licence of residential premises. London and Quadrant was held to have granted Mr. Bruton a tenancy agreement. So the agreement as between L&Q and Mr. Bruton was a tenancy agreement. But the agreement by which L&Q held the property was a licence. The argument went to the House of Lords on the basis that L&Q couldn't have granted a tenancy agreement because you can't grant what you haven't got. And it was held as between Bruton and L&Q. L&Q was stopped from denying that there was a tenancy agreement because Mr. Bruton, the agreement that was granted to Mr. Bruton had all the incidents of a tenancy. If my learned friend is right, in such a situation again, Mr. Bruton could determine his tenancy agreement, and assured short-hold tenancies generally provide for the tenant to be able to give 4 weeks' notice to quit. He could remain in occupation and say to L&Q, you can't bring a possession claim against me. And that is right, even allowing for the estoppel as between the landlord and the tenant, because my learned friend's position is, and must be, that the estoppel ends once the tenancy is ended, because somebody with a licence can't bring a possession claim. And in my submission, that's an absurd outcome.
Well, his answer might be that, as the Court of King's Bench said in the Baytup case, you've got to actually give up possession before you can challenge the title.
My lord, yes.
In which case, Mr. Bruton, on your hypothetical example, couldn't simply terminate his tenancy, sit tight,
My lord, yes.
and then deny L&Q's title.
Except, in my submission, his submissions about the Baytup case really preclude him from making that argument, because he said, no, it's only the person who has the legal interest, Mrs. Johnson, who could bring the possession claim, and not
Miss Baytup.
No, Miss-
Miss Boscombe.
Backham.
Backham. Yeah.
Mary Backham. So I think if that is right, then these arguments are all. If he doesn't make that argument, like that, if he accepts that the licensee occupier is stopped from disputing their title of the person who granted them the license, their licensor, until they've left possession, all of this is arid. Because the defence accepts that, in this case, Maria Laleva entered into occupation pursuant to a licence granted by us. So she can dispute our title, but only after she's left.
Well, that's not quite the way Mr. Wanacott puts it. He says the only title you claim, this title is whatever. Are your rights as a licensee, and that, he says, is not enough to give you this particular remedy. You may have other remedies, but not this one.
No. Sorry, I understand that that's what he's saying, and in my submission, that's why he would be precluded from responding in the way with the argument that you suggest he might run. So, if I could deal with it in this way, if I could submit why it is clear that Manchester Airport and Dutton was not decided per incuriam, and in any event, if it was, it's now irreversible, and then if I could deal with the Estoppel.
Yeah.
So I got as far as Mayor of London. Sorry, if we go back to Manchester Airport and Dutton, in my submission it's clear that Lord Justice Laws and Lord Justice Kennedy were aware of the position prior to their judgment in Manchester Airport and Dutton. And the reason it's clear that they're aware is because Lord Justice Chadwick made a dissenting judgment, effectively relying on the position relied upon by my learned friend. It's clear that Lord Justice Laws had read Lord Justice Chadwick's judgment before writing his own, or before finalising his own, because if you turn to page 147 in the judgment, 177 in the bundle, letter E,
Yeah.
you'll see he says, halfway across the page, right opposite the letter E, this, as it seems to me, is in line with the passage in Lord Upjohn's speech in National Provincial Bank Limited and Hastings Car Mart Limited, 1965, appeal cases 1175, which Lord Justice Chadwick has already cited and is supported by the judgment of Mr. Justice McGarry in Hounslow, London Borough Council and Twickenham. So he was aware of the line of authorities and the argument about having to have title in order to bring a possession claim. And if you move on to the decision of Lord Justice Kennedy, the judgment of Lord Justice Kennedy, my lord, my lady, which is on page 180 in the bundle, page 150. Again, going to the passage referred to by my learned friend, you'll see there that Lord Justice Kennedy refers to the case of Danford and McAnulty. Which is one relied upon by him to support his arguments.
Well, it's his comment that's the important bit, isn't it? He says that wasn't concerned with the licence, but the emphasis was on giving a remedy to the party who has the better right.
That's right. My lord, I accept that, but in my submission, my learned friend has to show, in order for the case to have been decided per incuriam, that the court was unaware of a line of argument, some propositions, of law.
No, no. He has to show that the court decided the case in ignorance of binding authority or a statutory provision, not a line of argument.
My lord, yes. No, sorry, I apologise. In my submission, it is difficult to argue, having regard to the fact that the court had Lord Justice Chadwick's decision before it when they made their differing decisions. That the Court of Appeal in Manchester Airport and Dutton was not aware of the position adopted by the court prior to the decision in Manchester Airport and Dutton. But if you find that it's arguable that Manchester Airport and Dutton was decided per incuriam, well, it's my submission that now it's clear that proposition that a licensee can bring a possession claim if their licence gives them sufficient control over the land to found a claim for possession has now been accepted not only by the Court of Appeal but also by the House of Lords. So moving through the cases in order,
Just go back to the per incuriam point for a moment.
My lord, yes.
As Mr. Wonnacott quite rightly pointed out, Ashburn-Anstalt was referred to in the skeleton arguments,
Yes.
though not read to the court in oral argument and not referred to in the judgment.
No.
And in Ashburn-Anstalt, Court of Appeal did apply David Allen, King and David Allen.
My lord, yes.
So to that extent, the rule of law exemplified by King and David Allen was before the Court of Appeal in the Manchester case.
Except in David, King and Allen, it's undoubtedly the case that the lease created a greater interest in the premises than the licence that was granted to David Allen.
Yeah. Right.
And national provincial, if you look up the page on page 164, my lord, you'll see that other cases that were referred to in the judgments, including National Provincial Bank Limited and Hastings Car Mart Limited, and Hounslow Lumber Council and Twickenham Garden Developments Limited, were not only referred to in the argument, but also referred to in the judgment.
Yeah.
So the first case in the line of authorities which considered the Mayor of London and Dutton case, the first is Countryside Residential North Thames Limited and a Child and Persons Unknown, which is at tab 12, my lords, my lady. This is a very similar case in my submission to the Manchester Airport and Dutton case, in that it involves environmental protesters. They were far-sighted young people, really, given our current predicament, occupying land that was going to be developed. In this case, it was going to be developed for housing, and Countryside Residential had been granted a licence only for the purposes of inspecting the land to see whether or not they had an option to purchase, and then they were granted a licence to have a look at the land to see whether or not they'd exercise their option. And they brought their first claim for possession on the basis of those licences. And it was held that Manchester Airport and Dutton should be limited to cases in which the licence was sufficient to grant the licensee control and occupation of the land. So if you turn over to page 201, right at the very end, the developers, in this case Countryside Residential, did not have a contractual right to occupy or have possession with the effective control that is necessary if Dutton is to apply. They simply had a contractual right. But Dutton was approved to that extent.
Well, as Lord Justice Waller says, we've not heard argument on how far Dutton can be attacked in this court.
No.
If that's approval, it's quite muted approval.
My lord, it is, and it's right that it was just on the issue of costs. So possibly the court felt that they could resolve the issue by finding that in this case the licence didn't go far enough. But certainly Mr. Hutchings was keen to argue that Dutton was decided per incuriam. If you look at paragraph 9 on page 199, Mr. Hutchings was on behalf of the trespassers.
Yep.
In Alamo and Meredith, this court again found that a term in a lease which provided that after the lease had expired, the lessee, Alamo Housing Cooperative, had a sufficient interest in the land to bring a possession claim. Was enough to bring a possession claim.
Yes, so you've got that. We've got the clause at paragraph 39.
You have.
And what the court decides is at 42.
That's right.
Yeah.
So, paragraph 42, the situation must be judged as at the time when the council's notice to quit had taken effect. At that time, Alamo no longer had an estate in land. So it no longer had a title. However, since the council had, as is conceded, required Alamo to take proceedings to evict the tenant so as to be able to hand over the properties with vacant possession, it seems to us that the effect of the exception was to confer on Alamo a continuing right to possession for that purpose. And therefore, the situation is exactly as described in paragraph 39 above. That paragraph 39 deals with questions of the court to Mr. Carter, who was representing the tenant, Mr. Meredith. Mr. Carter accepted that there would be circumstances in which a clause in a lease would give Alamo a sufficient right to bring a possession claim. My lord, that perhaps brings us to your discussion with my learned friend about the extent to which a lease could be granted for a limited purpose, or is only a limited right of occupation being granted. In my submission, for these purposes, if you find that Manchester Airport and Dutton is now unassailable, in this case, and we'll come to it in due course, what was granted to the Guardian Group and by global guardians to G100 was sufficient to give it sufficient control over the land to bring a possession claim. My lord, in this case, Maria Laleva cannot say that G100 was not in possession before her, because G100 granted her her licence. possession historically has been regarded as evidence of title. Now, of course, in this case, G100 relies upon its license to occupy.
It relies on?
Its license to occupy as founding its claim for possession. But on my learned friend submissions, G100 would be able to rely on the fact that it was in occupation of the land before Maria Laleva, and that as occupation is evidence of title, it could bring its claim on that fictitious basis, that it has good title because it was in possession, and in effect we get the same kind of manipulation of the system that arose under the ejectment claims of using leases created for the purposes only of bringing the possession claim. The next case, my lord, in the line of authorities is Mayer, which I have dealt with, my lord, at tab 15. At tab 16 we have Mayor of London and Hall. This was the case involving the Greater London Authority Act, in which there were protesters occupying Parliament Square to protest against the Iraq War. Lord Neuberger gave the decision of this court. And my lord, at paragraph 22 of his judgment, on page 291 of the paginated bundle of 500...
Yes, there is a certain sense of déjà vu when you read paragraph 22.
Yes. So, my lord, my lady, for this purpose, that his discussion at paragraphs 22 to 28 are relevant. I won't read them out to you. But in my submission, what's clear from that is that Lord Neuberger is effectively accepting the views expressed by Lord Justice Laws in Dutton's case and by Baroness Hale in Mayer's case. If you look at paragraph 27, as approving the proposition that a possession order may be brought by somebody who only has a licence in the land. Sorry, possession claim. Apologise. The last case, my lord, is Astra Communities Limited.
So what do you say
Apologise.
is the status of paragraph 27? Is that part of the ratio? Because he goes on to say, even assuming that Mr. Wonacott's right, the answer lies in the statutory provisions. So is that obiter?
My lord, in my submission, the decision that Mr. Wonacott and Jan Luba QC accepted that Parliament could provide for who was entitled to bring a possession claim.
Of course.
But in my submission, that really rather defeats, doesn't it, the proposition that only somebody with title can bring a possession claim?
No. Mr. Wonacott's proposition is at common law, only somebody with I don't think he even goes as far as to say title. Only somebody with possession, who had possession, is entitled to bring a possession.
My lord, yes. I accept that what Lord Neuberger says in Mayor of London and Hall is obiter.
Yeah.
And then the last case in this line is Astor Communities Limited and Ackerman Livingstone. In that case, Mr. Ackerman Livingstone was had a tenancy from Astor Communities Limited of a flat in a block of 6 flats. Astor Communities held its interest on leases of each of the flats. before the case got to the Court of Appeal, Astor Communities determined the leases of the 5 other flats, they then being unoccupied, and the developer determined the lease of Mr. Ackerman, of the flat that Mr. Ackerman Livingstone was living in. At paragraph 70,
70, yes.
Paragraph 71, I apologise.
Material to the above effect. Yes. Yeah.
Sorry.
Isn't this all about summary judgment rather than who can bring the
This is
claim
about
to-
Disability Discrimination Act claims,
Yeah.
but Lord Wilson points out that all that Astor now has is a licence that has been granted to them for the purposes of enforcing the possession order made.
Sorry, where are you reading from? Paragraph 71.
Paragraph 71, right at the bottom of the page, little Roman I. It's not
I
a 1,
see.
it's an I because they're being done
Freeholder
alphabetically.
served.
On the 1st of May 2014, however, the freeholder served on the claimant notice to quit flat 1, effective from 30th of June 2014. Since then, the claimant has had no interest in flat 1, save that the freeholder has granted to it a licence to enforce the possession order made by His Honour Judge Denyer QC, if and when it can.
When was that? When was that order made?
The order of His Honour Judge Denyer QC had been made on a Part 55.8 hearing
Brought by Astor
brought by Astor.
before its tenancy, before its arrangement with the local authority came to an end.
Before the lease had been determined by the developer. So the possession order is made before the 1st of May 2014.
Right. So at a time when Astor had a lease.
Yes, the court made the possession order.
Right. So that's consistent with what Mr. Wanacott says. They had a lease at the time the possession order was made.
Yes, but they wouldn't be, on his position, they wouldn't now be entitled to enforce it.
Oh, I see. Well, yeah. Right.
So, my lord, my lady.
So what do you get out of this?
Well, that the Supreme Court at that point is accepting that a licence to enforce the possession order by a licensee could enforce the possession order made at a time when it was the lessee, as a result of a licence granted to it by the freeholder.
Yeah. Yeah.
So if I can now turn my submissions to the Estoppel point, which are based or derived from Doty, Johnson and Bateup at divider at tab 1. In my submission, the wider interpretation of that is clearly the right one.
That's Lord Denman. Yeah.
Yep. And the point is this: in effect, what Lord Denman is saying is that the estoppel that applies as between a tenant and their landlord also applies as between a licensee and their licensor. Because otherwise it's not a new proposition at all. And it's clear that the court regarded this as clarifying something that would not otherwise have been obvious. if my learned friend is right, only the freeholder can bring a claim for possession, or sorry, only somebody with title or control can bring a claim for possession, it wouldn't have mattered whether or not Miss Beta had entered pursuant to a licence, because the person who was bringing the claim was a licensee, and on his account, although not her licensee, authorised by her because the person who had granted the licence was her agent.
Sorry, I haven't understood that.
Right.
Could you
Yes,
put that again?
I can. So the claim was brought by the person who claimed to be have a title in the land,
Yes.
Miss Johnson. So my learned friend says all this is authority for is that somebody who has a licence cannot or is stopped from defending the claim against a person with title.
Yes. Transposed to the facts of this case, he would say that Miss Laleva, by accepting a licence from G100, is stopped from disputing the title of the NHS.
Yes.
But no more.
But no more. And we said, well, that wouldn't have been a new proposition, because the licensee must have less title than the freeholder or the person with title. So it wouldn't have been necessary to decide the estoppel point at all. So it must be that the wider reading of Johnson and Baituk is the correct one, and what in effect is being said is that a person who takes a licence is stopped from denying their licensor's right to possession until they have given up possession. And as you pointed out, my lord, the jury had found that the claimant, Mrs. Johnson, had not established title in any event. At tab 7 is a case of the government of the state of Penang and another against Un and others. But perhaps, sorry, what I should do is say that the case at tab 3, sorry, not tab, I apologise, tab 4, Tadman and Henman.
Yeah. Yeah, what do you get out of this?
So this is Mr. Justice Charles, page 171. He construes Doty, Johnson and Baituk at the top of the page at 171. And he says, halfway down the page, all that it decides of Doty Johnson is that a defendant injectant who has got into possession by the plaintiff's licence cannot turn around upon the plaintiff and say, I am in possession. If you want to turn me out, show your title. But if he wishes to dispute the plaintiff's title to the land, must first give up possession to the plaintiff from whom he obtained it. He goes on, the case concedes that a tenant or licensee may always dispute his lessor's or licence title, provided he first gives up possession of the premises.
Yeah.
So moving on to the Penang and Un case, my lord, my lady. In this case, the respondents were claiming that they were the owners of land that had been created by accretion from the sea, because it was adjacent to land that they owned. They had in the past had licenses of the additional land.
So who's claiming? The appellants?
No, the respondents.
Respondents. Respondents claim.
Sorry, they defended a claim for possession. No, that's right. I apologise. The respondents claimed title to the disputed land. The disputed land was land that was adjacent to land owned by the respondents.
Yeah.
And that land had been created by accretion from the sea. So it was additional, it was land that had not been in place at the time that the respondents had been granted, or had obtained ownership of the land. And if you turn to page 428, at C to F, the argument on behalf of the government was that the respondents were perpetually stopped from claiming title to the disputed land, because they had once had a license of it.
Yes.
If you move on to page 432 in the judgment, page 60, which is the judgment of Lord Cross of Chelsea, see, he sets out the facts, and then under
Which
paragraph 432, 460,
Yes. The Estoppel point. Yeah.
the Estoppel point. So he deals with the Estoppel point, and if you move over the page to page 433, starting at E, there is no doubt that under English law as it stood in 1872 and stands today, there is no difference as regards the matter in hand between a tenant and a licensee. Each is estopped from denying the title of the person from whom he accepted the tenancy or license, so long as he remains in possession under it. But each is permitted to deny that title as from the time he is no longer in possession under it.
Yes.
And so, my lord, I say that that makes it absolutely clear that the position isn't, as my learned friend indicates, that a licensee is stopped from denying the title of somebody with an estate interest. It is stopped from denying the interest of the person who granted them the licence. My lord, you circulated, my lord, a case, William Clark and Patrick AD, which is behind tab 29, I believe. It's a House of Lords decision of 1877. This was a patent case. And the person who...
basically, this shows that this principle goes beyond landlord and tenant. It applies to patentee and licensee under a patent.
My lord, yes, I was actually going... I'm not going to rely on it for the purposes of these submissions in response to the Estoppel point. It will become relevant when we deal with whether or not the court can construe what was agreed as between the parties by reference to the agreement that is accepted bound them. So that's why I don't deal with that
No? All right.
now. My lord, those are the submissions in response to the title and Estoppel point.
Right. So now we go on to part 55.8 test and its application.
We do.
Yes.
So, excuse me, I just need to turn up my relevant skeleton argument. So on the basis that I won't finish the submissions on this part of the appeal by 1 p.m, what I propose to do is deal with how Part 55.8 should be construed and the level of the test it establishes. So the appellant submission, my lord, is that the test under Part 55.82 is one which is at least as high and arguably higher than the test for avoiding summary judgment.
Can I just understand, if it is higher than the test for summary judgment, what is it? What is the test? It's not balance of probability, it's not full trial,
No.
because that's yet to be determined, if you
Yes.
satisfy this superior test, whatever it is. So what is it? It's more than real prospect of success in the defence.
Yes. So there are two reasons why we submit that the test is at least as high.
Well, leave aside summary judgment test. That was
Yes.
one of the reasons I wanted you to look at that case
Yes.
on the insolvency rules, which uses what, to my mind, are strikingly similar words to what's in Part 55.
My lord,
But-
it does, but it uses the two adjectives in conjunction, whereas the setting aside a statutory demand
Well,
test.
we'll come to that in a minute. I just want to understand, if the test is higher than summary judgment, what is it?
That the defence has a substantial prospect of success.
Substantial meaning more than a real prospect of
Absolutely.
success. So
So if we think of the words real and substantial in there as they're used in common parlance, something that is substantial is real, but something might be real without being substantial. So that if you had a Venn diagram of what is substantial and what is real, real would be a big circle, and then substantial would be a smaller circle inside the word, inside the set of things that are real. So something that is substantial must be real, but it's more compelling than something that is real.
right. So if I own some land and somebody is on the land and I want to sue them for damages for trespass and an injunction stopping them from entering the land, they can defend if they can show a real prospect of success.
Yes.
But if I want possession from them, then they've got to show rather more than that.
Yes.
Is there any reason why that should be the case?
Well, my lord, we're bound by the civil procedure rules, and they're a
fine,
complete
of course.
code. And the people who drafted them who drafted Part 55, must have been assumed to have known what the test in Part 24 is.
Yeah.
They didn't use the same words.
Right.
And it would have been perfectly open for them to use exactly the same words.
Yes.
So the case that you circulated, my lord, Collier and Wright, which is behind divider tab 31 in the authorities bundle. In that, this court, Lady Justice Arden, as she then was giving the judgment, held that the test for setting aside a statutory demand, firstly she found that the burden was on the person making the application.
Yeah.
And secondly, construing the words which are the relevant provisions for the setting aside of a statutory demand, that at page 648B, reliance is placed on B, the debt is disputed on grounds which appear to the court to be substantial. The wording "a genuine triable issue" appears in the relevant provision of the practice direction. So the words that were used or are used for the setting aside of statutory demand is that the debt is disputed on grounds which appear to the court to be substantial.
Yes.
Now in part 55.8 we have the two adjectives that are used, one in the rules and one in the practice direction in relation to setting aside a statutory demand, elided so that the case is genuinely disputed on substantial grounds. It might be thought that genuinely means the same as substantial.
Sorry, 55.82.
Yes.
Where the claim is genuinely disputed on grounds which appear to be substantial.
Yes. So we've got both genuine
Yes.
and substantial as adjectives that define the level of...
Right, so the difference is in genuine.
Well, both words are used together. Genuinely disputed on grounds which appear to be substantial. So the grounds must appear to be substantial and the dispute must be genuine.
Right.
Now,
the dispute here is genuine, isn't it? In this case, genuine is not a manufactured, made up, fraudulent, whatever. I don't know quite what the opposite of a genuine dispute is.
no.
But I think we can see by the presence of two counsel on Mr. Lever's behalf that there is a genuine dispute in this case.
But if the presence of counsel was enough to establish that the dispute was genuine, in my submission that that would leave a position where people who are unrepresented at a disadvantage.
Well, come on, Mr. Ruddy. How do you tell whether whether a disputed claim is genuinely disputed? What does that mean? What's its opposite?
Disingenuously, I suppose, disputed. Disputed without substance.
Right. So what does that add to on grounds which appear to be substantial?
Well, it doesn't. I accept, my lord, that it doesn't appear to add very much. But both adjectives have been used.
Is it a hangover from bona fide disputed on substantial grounds, which is the wording that's been used since time immemorial in cases on disputing winding up petitions in companies law?
Well, it may very well be that the word genuine is used in this context because the civil procedure rules moved away from the use of Latin phrases in the rules.
I think that's
and
not
genuinely...
Justice Snowden's point. I think he's asking whether the origin of this concept is in the way that the winding up court would deal with debts which are said to be disputed.
My lord, I don't know how the word genuinely disputed or genuinely came to be used in the rule.
Yeah, right.
I mean, I'm happy to accept. I don't argue strongly that the test is significantly different from the summary judgment test.
Right. All right. Well,
but there is a concern that both adjectives, genuinely and substantially, are used, and they can't mean the same thing, because if they meant the same thing, there'd be no purpose of including both of them.
Yeah.
I mean, I accept that genuinely goes to the bona fides of the dispute. But of course, in order to be substantial, a ground would have to be bona fides anyway.
Yeah, right.
in his judgment, His Honour Judge Luba QC relied upon the word appears as in effect giving rise to a lower level of certainty on the part of the tribunal, or a lower level of confidence, I suppose, in the tribunal that the dispute was a substantial one. I think from my learned friend's skeleton argument that they accept that the word, His Honour Judge Luba was wrong in that regard, and the word appear is there because it deals with all of the different circumstances in which a district judge might be making a Part 55.8 decision. Which we set out in our skeleton argument. So the Part 55 process is a modified form of Part 8 procedure, but the defendant can take part whether or not they filed an acknowledgement of service or defence at that hearing. So the judge may be faced with somebody who hasn't filed a defence and just turns up. They may be faced with somebody who has put in something in writing. They may turn up with the duty solicitor to whom they've explained their case, or as in this case, they may turn up with a fully pleaded defence represented by specialist counsel.
Yeah.
And in my submission, the word appear for these circumstances is to take account of all of those different circumstances and indicates that the judge has, in some circumstances, an inquisitorial role, or has to tease out from an unrepresented defendant what their substantial grounds are.
But you don't get that from the word appear, because that's also in the insolvency rules. You get it from the structure of Part 55, and in particular the fact that a defendant who hasn't said anything before the hearing can turn up at the hearing and take part in it.
Absolutely. Yes.
Yeah.
So, my Lord, we would rely on the authority of Collier and Wright as authority for the proposition that the test under CPR Part 55.82 is the same as the summary judgment test. If you're not with me, that it's a test that is slightly higher regarding the defence to be substantial rather than only real. My Lords, I don't know if that's a convenient time. If we,
well, I think let's use the next 10 minutes. We might as well, since we are keeping to the timetable, minus the 15 minutes, which we lopped off it at the beginning. So let's carry on.
My Lord, yes. So in this case, the next issue is on what basis could His Honour Judge Luba QC have found, what did His Honour Judge Luba QC have to find that the district judge was wrong? So, you, my Lord, in Birmingham and Stevenson, an authority at tab 21.
Yeah, well, that was a very different case.
It was a very different case, but you and I will submit, because I think it's a submission on behalf of Maria Laleva, that because that concerned Disability Discrimination Act defence, which involves quite a large range of discretion on the part of the court, that the district judge was wrong in that case.
Well, it was partly that, but partly the district judge didn't allow Mr. Stevenson to put in a defence at all.
No.
He'd made contact with the solicitor a few days before the hearing.
Yes.
The solicitor had barely had time to take instructions from him. Mr. Stevenson had obvious mental problems, had been seen begging in the local shopping centre.
Yes.
And the district judge said, effectively, I'm not going to allow you even to formulate a defence. It wasn't a case in which there was an evaluation of a defence which had been filed, which
Yes.
is this case. Here, the district judge and the circuit judge knew what the defence was going to be.
My lord, yes. Mr. Stevenson's position was even better in that the hearing at which the court shut out his ability to defend the claim was the second hearing.
Yeah.
But at the first hearing, the district judge had indicated that he was adjourning the case to give Mr. Stevenson an opportunity to file a defence. There hadn't been directions that he must file a defence. So it was clear that the first judge hearing it had recognised that Mr. Stevenson may have problems before the next hearing of actually formulating or filing a defence, because otherwise, presumably, he would have said, you must file a defence. But you held, my lord, in that case, that a Part 55.8 hearing is a case management decision.
Well, no. The decision that was made at that hearing was a case management decision because it was a decision not to adjourn it. But that's not the same as asking yourself, has the filed defence shown me that there are substantial grounds on which this claim is being defended?
My lord, yes.
That's a different question.
My lord, it is.
I think it's a point in your favour.
My lord, yes.
Which it may be not, because no, it's not. You say the district judge got it right.
We do.
And that was her evaluation of the merits of or the potential merits of the defence.
Of the defence.
Which Miss Laleva had filed.
Yes.
Now, that's not pure case management, is it?
It isn't, my lord, no. But in those circumstances, the court's position, in my submission, is difficult because if the decision is made not to adjourn, which District Judge Cooper decided not to do, she made a possession order. That's then under the authority of Birmingham and Stevenson, a case management decision. Because you say at paragraph 25, right at the last page, I recognise that the decision whether or not to adjourn a case is a discretionary case management decision. And she either had to adjourn it with directions or make a possession order if she felt that the case was...
Yeah, but paragraph 25 says that the Deputy District Judge, in effect, did not evaluate the merits of any possible defence. He simply said, I'm not going to allow you to put in a defence.
My lord, yes. Well, I'm not going to push it because I accept that a court would feel uncomfortable finding that a decision shutting somebody out from defending would be a case management decision with all of the difficulty that creates in relation to appealing it. So what I say is that His Honour Judge Luba had to find that the district judge was wrong to have held that the defences expressed in Maria Laleva's draft defence did not amount to genuine, did not create a genuine dispute on grounds which appear substantial. Yeah. Perhaps then if I deal with His Honour Judge Luba's findings in that regard after the lunch and adjournment.
All right. Right, 5-2.
Ayes.